Good morning, everybody. This is David Hamilton. I am a partner at DLA Piper in the Baltimore and Washington offices, and we are recording a new episode of our podcast called Pricing Rules. We focus on pricing conduct an awful lot, but we're going to take a slight turn in this podcast and talk about the role of state attorneys generals and the increasing activities for the state attorney generals and maybe some predictions as to what's going to happen in the Trump administration. We're lucky to be joined by Gwendolyn Cooley. Gwendolyn formerly was in the Wisconsin Attorney General's office. We're also joined by Sean Heather. Sean is the Senior Vice President for International Regulatory Affairs and Antitrust for the United States Chamber of Commerce. And then our last panelist is my partner, Vic Domen, a partner in the antitrust practice in the Washington, D.C. office. And in a former life, Vic was an AG in the Tennessee office. The reason we picked this topic is it's newsworthy, frankly. There has been, over the past couple of years, a fair amount of increased activity and more substantive roles taken by the state attorneys general in conjunction with the Department of Justice or the Federal Trade Commission, in conjunction with Biden executive orders, and in conjunction with their own rights and positions and policies that they want to take, whether it's in litigation or in legislation. So we thought that this was a timely topic and looking forward to our panelists' views. And let me just start with Gwendolyn, if you could provide a little bit more background about yourself.
Yes. Hi. Thanks, David. I think you're exactly right that this is a timely topic. I spent 20 years as the Assistant Attorney General for Antitrust in the state of Wisconsin, including the last 3 years where I was the chair of the Multi-State Antitrust Task Force. Currently, I'm developing a targeted artificial intelligence merger evaluation tool. It's called TAMET, which makes predictions for antitrust enforcement outcomes in mergers.
Sean, can you provide us with some of your background?
Yes, I'm the non-lawyer in the room who thinks about this through a policy lens, but I've been at the Chamber for many years. I actually cut my teeth not on state antitrust or AG enforcement, not on FTC, DOJ, federal enforcement, but actually on international enforcement, which is why my title's a mouthful. So I spent a lot of time thinking about China bringing on its anti-monopoly law, India standing up its CCI, lots of debates about the role of abusive dominance in the EU system, these kinds of things. But the Chamber historically hasn't cared a lot about domestic antitrust because there was kind of a bipartisan consensus that existed for much of the last 40 years. But that all changed with this neo-Brandeisian movement. So for the last 4 or 5 years, I've had to focus much more of our attention at the Chamber and what's going on in Washington. And I think this conversation is very timely because these things are moving outside of Washington. I suspect we're going to see more activity in the states, both from state AGs, but also out of state legislatures.
Thank you. Vic?
Yeah, and I'll just add to what's been said. First, thank you to both Gwendolyn and Sean for joining us today. Prior to coming into private practice in 2019, I spent 20 years in the Tennessee Attorney General's office working with my fellow AGs and fellow AGs' offices with the Federal Trade Commission, the Department of Justice, and we brought many, many suits over that period of time. But I will say, too, things have certainly turned in different directions than I anticipated when I left public practice.
That's great. Thanks to all of you. Let's just start with the topic that was suggested by Gwendolyn, and that is a crash course on what attorneys general do and how they do it. Since it was your suggestion, Gwendolyn, go for it.
Well, I will say that the first thing to know that always surprises people is that there are 56 attorneys general across the country. Most of those folks operate through the National Association of Attorneys General. There are 4 AGs who have withdrawn from NAG, all Republicans, but most of those folks work through the National Association of Attorneys General, NAG, as we like to call it. NAG is the AG level group that has a staff level group called the Multi-State Antitrust Task Force. So that's the thing that both Vic and I have led at various times. That has about 270 attorneys across the country who do antitrust. So as Sean was alluding to, states do both merger cases and they do conduct cases. And the conduct cases generally run the gamut. You see big tech kinds of cases. You see pocketbook issue kinds of cases. You see hospital investigations. And then also mergers. And those range from some larger national mergers. So some of those larger cases, but also those smaller cases that have local impacts. Typically, one of the most common ones that you see is in hospital transactions. Obviously, state attorneys general have the most experience with what the market looks like and helping to figure out what the market definition is for those transactions beyond just looking at zip codes. So that's kind of an overview of what the states look like and how they approach cases generally.
Right. And just to add to that, too, one of the things I think that folks may not recognize or realize is that there is a lot of coordination between the states, right? There's a lot of communication. There's a particular issue that might be on the national scene. You can probably bet that the state AGs are talking with one another about those issues. It's not just California or New York or Texas doing something on their own. There is a lot of cooperation and collaboration among all the state AGs through the multi-state task force. And I think that's very important and critical. So if you think, for example, that your issue in Maine may not find its way to California, don't be fooled. You may just have something that someone in one state can ask a different state about to get an opinion if they don't have a particular expertise. And that's the key with the task force. It's the ability to pool all of the resources of the various state AG's offices around the country and work together. And you see that over and over again.
And that is absolutely true. There's a call every 2 weeks presenting everything that's going on in the country. So states really coordinate really well through that. But I will note that one of the things that's changed that happened during my tenure as chair is we were able to get the State Antitrust Enforcement Venue Act passed. That was supported by 53 attorneys general, so a bipartisan broad consensus. And that meant that states would be able to bring a case in the jurisdiction of their choosing. The venue if they're choosing. What that means in practical reality is that states actually don't have to cooperate with each other anymore, but we still do see that there are groups of states working together, and they are generally doing this through the Multi-State Antitrust Task Force.
So, Sean, you've been in a different perch. How do you see the evolution of state AG activities over the past couple of years?
So it may come as a surprise, but the chamber is actually welcomes strong antitrust enforcement. It's far better to have the government step in a surgical way and address conduct or block a single merger versus setting up more per se regulatory type approaches that really limit a lot of pro-competitive conduct. That being said, one of the things, the strength of antitrust law is that it's a law of general application. Everybody's asked to compete. It's also a law that allows lots of different groups to bring cases, whether it be at the federal government, whether it be state AGs, or whether it be private action. By and far, there's more private action in the antitrust space than there is either state AG or federal. And all a judge is going to ask you is, can you show harm within that consumer welfare type standard? And can you demonstrate that that harm is greater than any pro-competitive benefit? So that's actually a strength of the law, not a weakness. And the AGs play an important role in enforcement, along with the ability for private actors and the federal government to bring their cases.
So, Sean, part of what you said sounds like it edges right up to actually collaborating with the state AGs. Does the chamber ever seek to collaborate, or do state AGs ever seek to collaborate with the chambers?
When gatherings of AGs come together, the chamber is often there for parts of the program and discuss a wide variety of things. Oftentimes, we're there to talk about policy matters more so than collaboration on cases. But at the confabs where AGs gather, yes, we have a fairly active voice with AG groups talking about not just antitrust, but talking about tort reform and a variety of other policy type issues that AGs and their interests in state legislatures have.
Yeah, and Vic and Gwendolyn, how about collaborating with DOJ or FTC? Do state AGs do that, either in general discussions or any cases or merger actions that are being litigated?
Yes, to all. There's absolutely collaboration. In the most recent administration, the Biden administration, and I think continuing into this Trump administration, both agencies have specifically designated state liaisons, and that makes a huge difference in terms of making sure that we're as coordinated as possible, because the state attorneys general in particular, since they are the closest to businesses, it's very important to be as mindful of the power that an attorney general investigation has. So you want to make sure that you're as coordinated as possible when it is possible. It's not always the case that you're able to coordinate. I have certainly done investigations not with the federal government, but whenever we can, we try to do so.
Right. And just building on that, that was the role that Gwendolyn and I really served. She talked about liaisons. I think that as the task force chairs, we were typically viewed as the touch point for the DOJ and the FTC. And whether we were or weren't involved in a particular investigation or lawsuit, the heads of the antitrust division or the chair of the Federal Trade Commission would look to us to be the voice to speak to the states about the position of the DOJ or the FTC and see whether, in fact, there was an ability to collaborate or coordinate with them. And you saw that quite a bit. And it really doesn't matter which administration was in place. I worked through two different administrations, and I know, Gwendolyn, you did as well. And I think that it was one of those where it didn't matter whether there was a Republican president or a Democratic president, and Republican or democratically controlled FTC or DOJ, the relationship between the DOJ and the FTC and the states was always pretty good. Now, granted, there were times when we disagreed and we didn't, for example, join the DOJ in a particular case, or we brought it further than the DOJ wanted to, but that's just natural. And I think that happens even between the DOJ and the FTC. They have times where they disagree or diverge on decisions and don't necessarily walk arm in arm through a particular matter or case. But I think that over time, the DOJ and FTC have really recognized the importance of the state AGs, and that's something that's only going to grow and continue.
I would agree with all that, although we are at an inflection point where increasingly we're concerned that antitrust is becoming politicized. And we see it at the federal level, and it certainly is worth noting at the state AG level. And that's a problem because antitrust has long been a very technical matter of law. It's a marriage between not just the law, but economic analysis. And if we begin to politicize the role antitrust plays, I'm not sure that that is good for any of us as an economy and as a country. It's also worth noting we've done a lot of polling. Obviously, unlike the DOJ and the FTC, who are not elected officials, state AGs are. You all go on the ballot before the voters, so there's some direct accountability there. But antitrust does not exactly poll well amongst the American voter. It's not as if when you think about what they're looking for from their elected officials, that antitrust ranks high. We've done a lot of focus group work on this, and people believe in competition on the merits. They believe that if someone's taking a shortcut to competition on the merits, that's important. But some of the grandstanding we see and have seen a lot of actually in the last 4 years, particularly at the federal level, that doesn't seem to resonate with the voting public.
That is not my experience at all. My experience is that the American public, while many, I agree with you, do not necessarily know about antitrust, that has really changed in the last 5 or 6 years. And we would regularly hear from constituents about antitrust issues. And if I think about farmers, for example, they were obviously very concerned about the potential for consolidation in their supply chain. So I actually saw something a little bit different than you guys are talking about.
Well, let's go there a little bit. Let's talk about something that has happened recently that has both a political nature to the statements and also at the level where the consumer understands it, it does mean the use of antitrust. And that's the Attorney General of California, Rob Bonta, announcing that pocketbook issues are his most significant concern. Well, for me, and I don't consider myself to be much more than your average person in understanding that, that means that the Attorney General in California is going to look at something that affects me as a consumer, whether it's a grocery store or whether it's technology, and he's going to use antitrust to address those issues that he considers to be pocketbook issues. What do you all think?
I think that's absolutely true. And I think it's one of the focuses. Sean mentioned that we are talking about elected officials for the most part. So they are responsible for responding to the consumers and constituents in their particular state. And they do look for particular issues that might resonate with the voters. I think that what we have to think about, though, is not just, for example, the cost of a gallon of milk or a dozen eggs in the store, but I think also healthcare is a particular one that really is important to almost every consumer. And I think that as people see prices rise and things get more and more expensive for them when they go to the doctor, that resonates with them. I think also we're talking about antitrust, but I think consumer protection issues are also very critical for state AGs. And oftentimes, as Gwendolyn said, we've got 270 AAGs doing this. Many of them wear both hats, and they'll wear an antitrust and a consumer protection hat. So the person may, for example, one day be working on a price fixing case, and then the next day, for example, in California, dealing with price gouging related to the fires in California. I know that General Bonta has really made a big point of that as well. So anything that's consumer facing like that, whether it's antitrust or consumer protection, is going to be a priority for the state AGs. And that's one of the things that they feel they've been given kind of the authority by the voters to pursue.
And I think all things can be true at the same time. So often in our debates, we try to say that it's either this or that. And what I mean by that in this case, if you look at the cases in big tech that the federal government has brought, I don't think those are pocketbook issues. And therefore, I'm think they're harder for voters to access and understand. When you move more to pocketbook type issues and cases that affect what people are paying in the market on a regular basis, there's going to be certainly more resonance in terms of the ROI. And to your point, Gwendolyn, you can find a small business or somebody who's not happy with the way in which the market is structured and the way in which they feel that they're not getting what they want out of the market. Antitrust has always been leery about competitor complaints, and they've always put those through the paces to determine whether or not those are legitimate concerns or whether or not those concerns are just the fact that the market is adjusted in a way that these people aren't able to compete. So, I mean, we have small businesses as members here. It's not uncommon that when these policy conversations are talked about inside the chamber, we have some businesses that take a particular parochial view of things, and you have to sort through that. And what I worry about when we talk about politicizing antitrust is that skepticism that antitrust is long held just because a competitor walks in the door and says, I have a sob story to give you. I think we see both at the federal level and at the state AG level more sympathy to those stories than we once did. And I think that's where we're starting to move antitrust from being that professional discipline to one that's a little bit more politically charged.
Great discussion here. Let's move a little bit toward something that we can't escape. How many times a day do you hear the words artificial intelligence? Can we talk about how the state attorneys general view the regulation of artificial intelligence?
It is an early day when we are talking about regulating artificial intelligence. And I think to Sean's point earlier, there is not a lot of appetite for full-on regulation of artificial intelligence amongst the state AGs, although there are some states that are considering bills like that. And maybe Sean can talk about that more. I think in California, they're looking at some kind of regulation of artificial intelligence. As a general matter, I think that thinking about antitrust and artificial intelligence, really what we do typically think of is related to pricing conduct. And what people conflate artificial intelligence with algorithmic pricing, those two things are not the same at all. But I think that's typically when we're hearing about that related to antitrust.
Right. And often it's a reaction to what they're seeing in particular cases. So, Gwendolyn, you mentioned California. I think Colorado has introduced legislation. I think that Utah has as well. So when particular cases are hitting a docket, different legislators around the country say, well, this could be an issue or a problem for our consumers. So let's float a bill and see if it has some sticking power. Often, though, it is a reaction to a particular matter that's risen, whether it's, once again, a healthcare issue or a rental property issue or a casino hotel pricing issue. It's one of those things where a legislator will typically see something, work with the AGs at times, and try to get that kind of legislation introduced. And that's what we're seeing right now, I think, with AI. Some states and legislatures have decided that.
Yeah, Sean, before you comment on that, we have an article on Senator Klobuchar's bill on algorithmic collusion, which we wrote on last year, and again on the new version, which is the same bill, but the things that have changed since she introduced it last year. Sean, go ahead on AI, please.
Look, I think people sometimes want to find new issues where there aren't any. We already have lots of experience with pricing practices that rely on data for how one sets price. The fact that there's now the ability to potentially cull more data to do it with speed doesn't necessarily suggest the laws on the books aren't capable of dealing with that. I think what's most interesting here from a policy standpoint is when you have absence of an agreement, can you bring an antitrust case? The fact that a number of parties may all be using the same software, that software may be giving all of those people an output then they're relying on as they go into the market and set price. But there is no agreement between the parties to collude. Is that an antitrust violation? And I think the answer to that question today is no. The question is, though, does that create a competition problem? And not every competition problem is for antitrust to solve. And I think theoretically you do have a competition problem if everybody is relying on a price that comes out of an algorithm and that price is not a market clearing price. Certainly, there are 2 gas stations on every corner in America. It's not ironic that they have the same price often. There's been plenty of price signals that are going in to the market. And if the market price coming out of all of that is an efficient market clearing price, then it's not an antitrust problem. If that price output is one that is doing something other than creating a market clearing efficient price, then perhaps you have a competition problem even absent an agreement. And that's the question, I think, for antitrust law is, can antitrust law reach that problem? I'm not sure we've identified that problem for certain. It may be a unicorn type situation, but at least it's worth an academic discussion.
Yeah, the only other thing I would add is I kind of alluded to this before. There is a difference between algorithmic pricing and using artificial intelligence for pricing. Essentially, if you have an algorithm or are using an algorithm, that is a much smaller subset of things. But if one were to go to a large LLM that is available online and type in, what should I price my good? I think it is going to be a more difficult case. Exactly what Sean is saying. I think it's a more difficult case to show something like that is a conspiracy, even if everyone is doing that kind of thing, unless you as a prosecutor have those conversations that would show, we've all agreed outside of this AI tool or outside of this algorithm. Seeing those kinds of conversations amongst the competitors really bring that rimless conspiracy into what antitrust nerds call a rimmed hub and spoke conspiracy, which I think that's going to continue to be a crucial aspect of those kinds of cases.
Right. I think that's a great point. And I think that even if there's, I would hate to use the word intent here, but if you see that the result of using this products tends to lead to increased prices across the board, or everyone adopting the same price in a what could claim to be a collusive environment, you're setting yourself up to receive that CID or subpoena. So I think one of the important things for people to consider is don't necessarily fall into the trap of just buying and accepting everything the machine is spitting out at you. Go back and look, do an analysis and determine, wait a minute, now I'm using this product and every single time I do, my prices go up. I wonder why that is. Second, what's the data being used here? Is it everyone else's? Is it anonymized? Is it all competitively sensitive? I think the onus is on the users of that system to really think about the impact. Step back and don't just take what the computer's spitting out at you as gospel. Go back and say, what is the overall impact of the use of this? And am I potentially putting myself at risk by just following the machine and doing what it says? And I think that's something that right now everyone's so anxious to use AI to help them optimize and become a better business and be more profitable. They're forgetting to step back for just a moment and really recognize whether they're placing themselves at risk unintentionally. And I will use the word unintentionally by just simply buying everything that computer is telling them to do. And I think that's where there needs to be kind of a course correction, because when I was in the state AG's office, or Gwendolyn was, or the FTC or DOJ are looking at this, they're looking at it through a prosecutor's mindset. And to them, they can piece together a story about why this looks to be anti-competitive and in some cases either monopolistic or collusion among the parties. And then you've got to dig yourself out of that hole that you've dug for yourself. So I think that's something to really consider.
Not to take over the moderating duties, but I think that's sound advice, Vic, to clients to avoid themselves the hassle of an investigation. But you put the nail on the head. It's a narrative that the AG's office can bring. Ultimately, do you think, though, without evidence of collaboration and an agreement, that would be a successful antitrust case?
Maybe not. I think we're at that moment in time where we're trying to determine that and figure out whether, in fact, that's the case. And you never know. I mean, you may know in your heart you haven't done it, but that doesn't mean a jury or a judge is going to buy it.
All that's fair. And that's why I think in some ways, some of this stuff may be a competition policy question and not always necessarily an antitrust question. That's not to suggest that, and maybe there is a need to modify the law. One might argue that at the federal level, this could be a UMC type question for unfair method of competition type question for the FTC Section 5 authority, absent an agreement. So we'll have to see where this area of the law evolves, but it's definitely worth watching.
Yeah, I agree. I mean, I would say that because it is uncertain, the instinct certainly is that those communications with competitors, those are going to be problematic, right? If you're having actual communications that you're going to rely on the algorithm or you're going to rely on the artificial intelligence tool, that's going to be problematic. I think that's pretty clear. It's the other stuff, because we don't know what that boundary is, because courts haven't decided that, because it's, regardless of what the agencies and the attorneys general think, it really is courts that make those decisions. So because we don't know, it's certainly a word to the wise.
I wish we could keep going, but I'm afraid we can't. And like all of our podcasts, we only cover about 10% of what our outline looks like. So we may have to do episode 2 or come back in a year and say what's changed. But for now, with the way that we like to wrap up this podcast is to go around and say, what do you see around the corner? What are you looking at in the way of developments now and for the future? So Gwendolyn, you go first.
Well, since we were just talking about artificial intelligence, what I see developments around the corner is an increasing use of artificial intelligence, both for companies who are looking to maximize their efficiency, but also for enforcers who are looking to review documents faster and review transactions faster. And I think that's really going to be game-changing in what has been a very slow process. While the antitrust laws haven't changed in 130 years, I think the way they are prosecuted is going to change.
Sean?
Watch state legislatures. We're going to see, I think, a lot of not only antitrust legislation, but also, as you said, Vic, consumer protection legislation. And some of this stuff, particularly in the pricing space, can be reached either through changes in antitrust law or it could be reached through changes in consumer protection law. There's going to be a lot of energy, and the AGs are pushing for new authorities and powers before their state legislatures, and that's certainly a space that we're watching closely.
Vic?
Right. And just to cap that off, I think that that's right, Sean. I think that you'll see some increased legislation. I know California, for example, has introduced new legislation to really increase the penalties that they can seek through antitrust. And there are bills floating around that try to change the evidentiary burden on the enforcers. So I think the AGs have realized that, and it's probably taken a decade, realize they have a lot more power than they were probably utilizing in the past. And they've begun to really assert that power now. So I think you're going to see more state AG action, which is independent from the DOJ and the FTC, at least from particular states. But one thing I want to leave everyone with is, although there are cases on the edges that seem to create some fracturing between the state AGs, for the most part, they work very well together as a cohesive unit through the Antitrust Task Force. So when there's a matter that has either local interest or national interest, you can expect the state AGs to really make a point of getting involved with that, either on the investigative side or in the litigation side, too. It's one of those things I think Gwendolyn and I have preached for years. Do not forget about the state AGs. They are not shy anymore about getting involved with a particular matter.
Well, and to your point, Vic, one of the things that I'm looking for is something we haven't talked about, but whether the trickle-down effect from Department of Justice and the FTC's investigation into labor markets, whether that happens at the state AG level. We didn't have time to talk about that, but that's something that I'm going to be looking at for the future. So with that, I think we have a wrap here, and I thank my great panelists for the wonderful discussion. Again, I wish we could go on for a while. It might take us a couple hours to finish this off, but thank you so much, and we really appreciate your time and your efforts.
It's great to be with you.
Thank you.
Yes, thank you.
Thank you for listening to DLA Piper's Pricing Rules podcast. All information, content, and materials contained in this podcast are for general informational purposes only. This podcast is intended to be a general overview of the subjects discussed and does not create a lawyer-client relationship. Statements and opinions are those of the individual speakers and participants and do not necessarily reflect the policies or opinions of DLA Piper, LLP US. The information contained in this podcast is not and should not be used as a substitute for legal advice. No listener should act or refrain from acting with respect to any particular legal matter on the basis of this podcast without first seeking legal advice from counsel in the relevant jurisdiction. This podcast may qualify as lawyer advertising, requiring notice in some jurisdictions. Prior results do not guarantee a similar outcome. DLA Piper, LLP US accepts no responsibility for any actions taken or not taken as a result of this podcast.